The majority of my time is spent being a financial advisor, running a boutique retirement planning firm, but that's not the whole origin story. I actually have been an estate planning attorney for over 20 years, and we still run an active estate planning practice for our clients that we do our retirement planning for. And I'll tell you, without fail, I look at three things when the moment somebody walks in to try to figure out if they've already got a great estate plan or if there's some adjustments that they need to make. The first thing that I'm looking at is the incapacity documents that they have. And really, I'm talking about powers of attorney and advanced healthcare directives or living wills. Why are these so crucial? It turns out that you are more likely to have some form of a catastrophic health event that will screw up your estate plan than it will be the fact that you just simply die without documents. In fact, the law is set up that if you have no documents, you get the result that you're thinking of, which is that your spouse is going to get stuff and your kid's going to get stuff. But if you become incapacitated, there are all kinds of problems that can happen. And so we want to make sure that you've got really good, robust incapacity planning documents, a power of attorney that's nice and long with lots of provisions, and a healthcare directive that plainly states out the care that you want, as well as who's going to be making choices for you. The second thing that we're looking at is whether or not somebody has a will-based plan or if they've got a trust-based plan. And here I've often got to talk with clients about the fact that having a trust isn't just for people who are wealthy. In fact, you might want to think about a trust, the entrance fee, not being about net worth, but about the organizational structure of your life. It turns out that when things are held in trust, you've got a nice tidy box and everything in one place, which makes it easier after you pass away, rather than having lots of cats running around with your life and then your kids got to go collect all of these cats and then marshal them after you're gone. So we really emphasize having a revocable living trust over having a will as the best planning platform for them. The third thing that I'm looking at was actually a development over my estate planning career, because when I started out, we were just doing what might be called death planning. That is what happens when you pass away. But more and more people are living longer and often getting sick. And so we want to look at what kind of estate plan has been set up to help them manage long-term care expenses. And because I am a lawyer and I've spent the majority of my career practicing law, we actually have different tools than most financial advisors to help manage long-term care expenses. Everything is not solved with just a long-term care policy, and many times the people that we meet may not qualify for it with their health concerns. So we want to make sure that we've got those things taken care of with a good plan that matches where they are in life and the kind of outcomes that they're looking for. So those are three things that I look at as an estate planning attorney that masquerades as a financial advisor, which is that we look to make sure that they've got great planning documents in case they become incapacitated or disabled. We want to make sure that they have a revocable living trust as the foundation of their plan rather than the will as the foundation. And the third thing is we want to make sure they've got a great asset protection plan in case they need long-term care as they get older.